Hello everyone, big warm welcome to our Young Dementia Network Tea Time webinar. I'm Tessa, I'm chair of the network, and it's my pleasure to welcome you and also to welcome Jacqueline here today. Thank you very much for joining us and contributing, Jacqueline. A reminder that panelists such as Jacqueline will be seen and heard throughout, and that attendees won't be seen and heard, but we really do encourage you to participate in contributing to the chat, and Jacqueline will be leaving some space and time in order to answer questions. So do use the Q&A as well as questions occur to you. With no further ado, I think I'll hand over to Jacqueline, and really looking forward to the content of this very important one. Planning for the future.
Thank you very much. So I'm going to cover wills and lasting powers of attorney. And I think I just wanted to say at the outset that I think they tend to have a bit of a reputation about being just for the elderly as we get older, perhaps when we come up to retirement age. That's the point at which we need to think about these. But that's absolutely not the case. With lasting powers of attorney, we probably ought to be thinking about them when we reach 18, but certainly as we go through life, there can be many reasons why we might or the time might come whereby we might need somebody to support us or to help us to make decisions for ourselves. And, you know, with wills, you know, really we encourage people to start putting a will in place, you know, when they buy a property or when they have children, and think about putting guardians in place. So it's really important not to think about either of these two aspects as being just for the elderly, and putting things in place sooner makes it easier. I'm going to talk about capacity today, and you know, if a diagnosis of dementia, for example, has been made, then that's really a trigger event to think about just checking the arrangements that perhaps you already do have in place, making sure that they're fit for purpose and whether anything needs to be changed. I think also looking at benefits, I'm not going to talk too much about benefits, but think about those that perhaps aren't means tested, so personal independence payments, formerly disability living allowance, and for some people perhaps NHS continuing healthcare might be available. So there is support out there. It's a question of knowing about it and then where to go for it. And although I'm a solicitor and I'm going to talk about lasting powers of attorney and wills, really I hope this is more of a practical talk for you. There is some legal basis behind it, but you don't necessarily need a solicitor, certainly for certain parts of this. So I'm going to start with decision making, and what we're looking at here is where somebody either is no longer able to make decisions for themselves, or perhaps doesn't want to make certain decisions. So some of you may already hold an enduring power or a lasting power. Enduring powers of attorney were introduced back in the 1980s, and they were replaced by lasting powers of attorney in 2007. For any of you who already have an enduring power of attorney, that remains valid, and you don't need to change it unless there's a change in your circumstances, which means that you need to replace the attorneys, for example. But they were replaced in 2007 by lasting powers of attorney. And if you like, they are the gold standard, because a lasting power of attorney or an enduring power means that whoever you appoint, your attorneys, can make decisions for you in relation to all of your financial affairs. That might be managing your bank account, dealing with savings, managing or applying for benefits, managing investments, buying and selling property, the whole range of financial decisions. It's not necessarily right for absolutely everybody, and I have highlighted a couple of other appointments that for some people might be a better option or might suit them better, but I would certainly never ignore lasting powers of attorney. And also I should say at the outset, when lasting powers of attorney were introduced, the government very much intended, or Parliament very much intended, that individuals should be able to put them in place themselves, that you shouldn't need to use a solicitor. So you can access them online, or you can obtain paper copies, and you can now submit lasting powers of attorney online. Some people will choose to use a solicitor, and in some cases, you may need to involve a professional, which I'll come on to at a certain time in the process. But for most people, certainly where incapacity is not an issue, you can access and deal and put lasting powers of attorney in place without the need for appointing a solicitor. Appointeeship is something which is made or given to you by the Department for Work and Pensions, and it is very suitable for somebody with relatively modest assets, perhaps one bank account into which their benefits are paid. In that way, the person can be appointed by the DWP with following an interview, and it means that they will be able to then collect in or apply for benefits, operate a bank account, and make payments. It will only cover those benefits and that bank account, but as I say, for someone with relatively modest assets, that's quite a flexible, relatively easy process to put in place. There are some more informal options. These aren't right for everybody, but where somebody still has capacity, but perhaps needs somebody to support them with a bank account, a short-term option might be a third-party mandate. That's where you nominate who you want to be able to access your account and to be able to carry out transactions for you. It is only valid whilst you still have the capacity to oversee what is being done. So it isn't really an option where mental capacity to make decisions might become an issue in the future. Also, having a second card on an account, some banks will allow that, but again, strictly that only applies whilst the person has capacity, in the same way as perhaps a third party having online access. This is a real difficult area at the moment, one that's sort of ripe for financial abuse, because it's much more difficult to oversee what is being done. But for some people, it works. But again, it should only apply where the person whose account it is knows what's going on. Something that the banks in the past suggested was setting up a joint account. So it's not unusual for a married couple to have a joint bank account. But another option might be, for example, for a parent and child to have a bank account in joint names. What is really important here is to understand whose account it is, and whether you are putting it into joint names for convenience purposes, which is usually the case, or whether you are actually genuinely making a gift of half of the account. The reason for this is that it's all very well whilst the original account holder is alive and somebody else is operating it, but on their death, the bank will treat it as though it has passed to the surviving joint owner, and it may not be that's what was intended. And there have been some difficulties with including these assets in probate and that sort of thing. So it's important that if you are going to put an account into joint names, you're really clear about the basis for it. And then finally, court of protection. I'm going to cover this in more detail later, but this is really where the state gets involved in overseeing and managing decision making for somebody who lacks the mental capacity to be able to make decisions for themselves. So the reason for the introduction of powers of attorney was a way of removing state involvement to a large extent and leaving us as individuals to decide who we want to be able to make decisions for ourselves. The lasting power of attorney provides the written evidence of that, and which will be accepted by banks and other financial organisations, or by doctors or local authorities in the case of welfare powers of attorney. But if somebody doesn't put a lasting power of attorney in place, or doesn't ever have the capacity, then the court of protection may be the only option if they have assets that need to be managed. So specifically lasting powers of attorney, as I've noted there are two types. I think most of us see the financial one probably as the priority. How am I going to manage somebody's bank account? How am I going to make sure that bills are still paid? All of that sort of thing. And that is really important. But increasingly, and now I would say equally important, is the health and welfare lasting power of attorney. These were introduced when lasting powers of attorney came in, and they enable you to appoint attorneys who can make decisions about medical treatment, consenting to an operation, being involved in decisions about where you live and what care you receive, and also about refusing life-sustaining treatment. So what you might include otherwise in a living will or an advanced decision. And we are increasingly seeing that when somebody moves into care, if the local authority is being involved in supporting the care or in any way at all, even if they're not financially involved, that the first question that a social worker will ask is whether there is a health and welfare lasting power of attorney. And the reason for that is that if there is such an attorney or attorneys, then they must be involved in the decision-making process about care, where that's provided, what the care is, and it ensures that your decisions about where you want to be are all taken into account, and those decisions are not taken away from you or the ability to make them and put into the hands of the local authority. So capacity. You can only enter into a lasting power of attorney if you have the necessary mental capacity. So you cannot take power of attorney from somebody. The donor, the person creating the power, has to give it to you. So what capacity is decision and time specific. So all elements of capacity are. So the capacity to make a power of attorney is very different to the capacity to make a will or the capacity to litigate or to manage one's own finances. So what a person needs to understand is what a power of attorney is, who they're appointing as attorneys. They need to understand whether those attorneys are going to get on. They need to understand that if they lose capacity, then the attorneys will be able to effectively take over and make all of the decisions that they would have been able to make if they had capacity. And crucially now, it also includes the capacity to understand what happens if I don't do a lasting power of attorney. And that's the ability to understand that whilst you might have capacity at the moment to manage your finances, that if in the future you become unable to do so, that it may be necessary for somebody to apply to the Court of Protection to have authority to act on your behalf. When somebody is losing capacity, a lasting power of attorney could be seen as something that's being taken away from them. That's really not the intention. They're supposed to enhance capacity and to provide extra support. And therefore, it's really important to do this early when somebody perhaps is not struggling too much in understanding what's going on. So in terms of then putting the power of attorney in place, as I've said, you can do all of this yourselves online or with the paper document without the need of a solicitor. But when choosing attorneys, it's important to think about who you actually want to appoint and do they get on. If you're married, don't forget your spouse, because spouses don't automatically have the ability to make decisions and to sign documents on your behalf. So if I have a bank account in my name, my husband cannot access or use that account at all unless he has a specific authority. You can have any number of attorneys. The form is designed for 4, but you can have more than that. Not always a good idea to have too many, but equally, if you want to ensure that all of your children are appointed, then so long as they all get on, there's no reason why you can't. And it doesn't matter where they are. So you can have attorneys who are not in the UK. There can be some practical difficulties with that, for example, proving your identity, but there's no reason why you can't have an attorney who's outside of the UK. When you appoint your attorneys, there are a number of options. The most usual option is what is called joint and several. That means that the attorneys can act together, but they can also act independently. And for most people, that is the most flexible option. You can appoint them jointly, but the disadvantage of that is, first of all, they always have to act together all of the time. And if one of them isn't able to, then the others can't. It also means if one of them becomes permanently unable to act, then the appointment of everybody comes to an end. You can appoint replacements. So if you would rather appoint one or two to start with and then have others to fall in at a future date, then you can do that. Again, not quite as flexible as the joint and several option, because a replacement can only come in if a prior attorney is permanently unable to act. And you can have decision making which is joint for some things and individual for others. That can be quite difficult to specify, so you'd need to think clearly and carefully about that. I've highlighted there the role of the certificate provider. Within the lasting power of attorney, this person is independent, so they can't be one of the attorneys, they can't be a family member, and they are there to independently verify that the person putting the power of attorney in place knows what they're doing, understands it, and has the necessary capacity, and they're not being unduly influenced. If there is any query about capacity, it will be the certificate provider who will be asked first to confirm that the person knew what they were doing. There are a number of options in terms of what you might want your attorneys to be able to do and not do, and those you can pick up from the Office of the Public Guardian, who then deals with the registration of lasting powers of attorney. So one option might be that you might want your attorneys to be able to see your will. They won't be able to change your will, but you might have included something in your will, such as leaving a gift to somebody, that the attorneys might be thinking of selling. If they can see your will, then they can make a decision based on all of the facts. Lasting powers of attorney have to be registered before they can be used. So registration takes place with the Office of the Public Guardian. It's a purely administrative process. The registration does not mean that somebody lacks capacity. It doesn't mean that the attorneys can take over. What it means is that for a third party, such as a bank, they'll be able to see that the document is valid. For most people, they put in place their power of attorney, register it, and then do nothing. A little bit like an insurance policy, it's there and in place if it's needed at some point in the future. And then the registration costs are currently £82 per lasting power of attorney. There is a fee remission for somebody on low income or assets, but for most people it's £82. So moving on in terms of using, I've just mentioned that you have to register the power of attorney before it can be used. For a financial power of attorney, it can be used even if the donor still has capacity, so long as they want you to use it and have given you authority. So for somebody who might be losing capacity or perhaps physically is struggling to deal with things, they might want their attorneys to be able to make certain decisions or certain practical measures which they can do even though they still have capacity. For the health and welfare lasting power of attorney, it can only be used when a person has lost capacity. That's because it covers personal decisions such as medical treatment, and you can't delegate those if you still have the capacity to make those decisions. When you need to use it as an attorney, for example, or because you want your attorneys to act, then you'll need to make sure the bank has a copy of it. Nowadays, what you would normally do is go into the bank, provide them with a copy. They will have a form to set this up, and then it gets sent off to their central branch that deals with registration for the bank's purposes, and so that it's then on their system and the attorneys can act. When you do that, that doesn't remove the donor or the original account holder's ability to access the account unless you specifically ask for that to be removed. With the health and welfare power of attorney, it's useful to let the GP have a copy once it's registered, so it's on your medical records. I've just flagged up copies. Don't send the original to anybody because it'll get lost in the post somewhere. But you can get certified copies. If a solicitor is preparing the document, they can provide you with those, or the public guardian can. Unfortunately, they have to be certified in a particular way, but a certified copy is absolutely the same as the original document. So court of protection. So I mentioned this arises when somebody never has had capacity, or where they didn't put a lasting power of attorney in place and now don't have capacity. And sometimes it also arises where there's a dispute between attorneys who were appointed but can't get on and make decisions, and the court removes them. And what happens is that the court appoints a deputy who will then have authority to make decisions. And a deputy is almost the same as an attorney. The decisions they can make are very similar, but it takes quite a long time to put in place. There are a number of forms that have to be completed, including a medical certificate. It generally takes at least 6 months for a deputy to be appointed, and that means in the meantime, managing somebody's finances can be very difficult because you would have no authority. And the costs are significantly more expensive than the power of attorney. It costs £365 to make the application. When you're appointed, there's a further fee of £110. Then there's an annual fee of £320 for being supervised. And as a deputy, you will generally need to complete an annual report setting out the money you've spent, the money that's come in, and the decisions that you've made. And that goes to the public guardian every year to be reviewed. You also, as a deputy, are almost certainly going to be required to take out an insurance policy, which in simple terms is to cover the risk of the money that you're managing being lost. And those costs, could be £50, £100 a year for the premium. So although the court of protection is there as an option, in many cases it can be avoided, and for most families it probably is best avoided. So moving on to wills. So I should just say, lasting powers of attorney arguably are more important than wills, because the power of attorney manages your finances for you and decisions for you whilst you're still alive. But having said that, wills equally have an important role to play. First of all, the reason to make it is that it creates certainty, because it means that your family, your executors, have your written instructions about what you would want. That really can help. Also, it avoids the intestacy rules. So the intestacy rules are the rules set out by Parliament about how an estate should pass if there is no will. And it makes no provision outside of family members. And it works really on a sort of list. So it starts with a spouse, it starts with children, and if there are none of those, then it starts looking at slightly more remote beneficiaries or family members. So parents, grandparents, aunts, uncles, cousins, and so on. But there's no discretion within that. And if you've got 10 cousins, then it gets divided between 10 cousins, for example. So if there is a spouse, the spouse doesn't inherit everything under the intestacy rules. In many cases they do, but there are limits. So the first £270,000 will pass to the surviving spouse. They'll also receive the personal chattels, which is essentially possessions within the house, books, jewelry, furniture, and so on. And then half of the remainder. The other half goes to the children. Now, although that might seem quite a lot, if the house is in the name of the spouse who has died, it's quite possible that the surviving spouse might not inherit the whole house, and the children might inherit a share of it. And that might cause some difficulties. If there are children, then children inherit at the age of 18. And personally, I don't come across many parents who want their children to inherit at 18. So Having set out the importance of a will and creating certainty, which is really what we're talking about here in terms of planning ahead, it also means that you can appoint executors who are best placed to be able to manage your own financial circumstances and on behalf of your beneficiaries. The will also means that you can include other people who wouldn't inherit under the intestacy rules. That might be a charity, it might be other friends or family members who are slightly more removed. For parents with children under 18, it means you can appoint guardians. If you've got a vulnerable beneficiary, the intestacy rules have no benefit really whatsoever. As I've said, in the case of children, they would inherit at 18, whereas lots of parents nowadays would prefer to extend that perhaps to 21 or 25, or even sometimes beyond that. But a beneficiary can be vulnerable for any number of reasons. As I said, it might be because of their age, it might be because of their capacity, it might be because perhaps they're not very good with money, or perhaps they're going through a divorce and you're worried about their spouse or ex-spouse having a claim. It might be because you want to try to protect assets from the cost of long-term care and to try to protect them. Even with the introduction of a care cap, it's important to bear in mind that it only covers the cost of care, not the cost of the accommodation. And therefore, there's going to be an ongoing cost of providing that going forward. The care cap probably only comes in after you've paid around 3 years of care fees. So wills have a place and a role to play in protecting assets and protecting vulnerable beneficiaries. And in many cases, that's done via a trust. In the past, trusts have been seen very much as, therefore, people with valuable assets. But really, they've been, the tax advantages of trusts that there might have been in the past really no longer exist, because they are taxed quite highly, but not in the case of trusts for protecting vulnerable individuals. In those circumstances, the tax position for a trust is usually exactly the same as it would be if the assets had been given to that beneficiary outright. And therefore, in those cases, the protection involved is worth more than the administration that there might be. Trusts also mean that you don't necessarily need to make a decision at the time you're drawing your will up, and you can leave the trustees to be able to make a decision and exercise their discretion at the right time. It can also support beneficiaries who may lack capacity and who, for example, may not have been able to put a power of attorney in place. There are various types of trust, and the suitability will depend upon a number of factors. They're often referred to either as a life interest trust, which is where somebody is entitled to the income but not the capital. These are often put in place on second marriages in the past. So, for example, if you have a second marriage but children from your first marriage, you might want to give your second spouse the right to remain living in the property, but you don't want to give them the property outright because you want it to pass to your children on his or her death. These types of trusts also have a good role to play if you want to try and protect assets from the cost of long-term care between a married couple, because you can give your spouse the right to live in the property, but not the ownership of the property, which means that your share isn't taken into account if they require long-term care in the future. Discretionary trusts are the most flexible option, and those are where you might have a number of beneficiaries that you want to provide for, but you're not quite sure exactly how it needs to be divided up. So they provide the greatest level of protection and discretion, although not necessarily the best from a tax point of view, but there are various options that you can consider depending upon circumstances. And then disabled persons trust, which aren't a type of trust of themselves, but have special tax status. And these are trusts which can be put in place for a beneficiary who is in receipt of a personal independence payment or DLA, or who would be entitled to that benefit if they applied for it. And in those circumstances, the trust can be run for that beneficiary primarily, to the exclusion of anybody else, but it protects that beneficiary's entitlement to means tested benefits, for example, and the trustees can decide how the money is used. And these types of trusts work particularly well where you are, for example, a parent needing to provide for a child, but equally for any vulnerable beneficiary where the trustees need to protect the assets, but also preserve as far as possible entitlement to means tested benefits. And then other factors to be taken into account when you're making a will. I did say that the tax really shouldn't be the priority, but it is an important factor for many people. Inheritance tax for some people will be a concern. Between a married couple now, well, certainly there's no inheritance tax payable between a married couple. We also now have the ability to transfer inheritance tax allowances between married couples, civil partners, which means that we each have an individual inheritance tax allowance of up to £325,000, which we can transfer to our spouse. There is also the residence nil rate band, which is an allowance that relates to your property, where you pass that down in general terms to the next generation. And this benefit is £175,000 for each individual. And again, this can be transferred between spouses. What that means for a married couple is that between them, where they have children, up to £1 million can pass down to the next generation free of inheritance tax. And linking that in with trusts that I was talking about, you don't need to leave your estate directly to your spouse. So if you feel that you need to protect the assets because they might need long-term care, then instead of leaving assets outright to them, putting them in a trust from which they have the right of occupation or the right to receive income, but not the capital, they will still be treated for inheritance tax purposes as though they have inherited the asset, and therefore you will still benefit from the inheritance tax advantages. And these are quite generous tax allowances, which could be lost with if there isn't a will in place. But also you can put together the tax advantages and the protection element of a trust. Protecting state benefits. So I've talked about putting a trust in place, which means that a beneficiary will still be entitled to their means tested benefits, because those are the ones that we're often wanting to protect. So a vulnerable beneficiary might be in receipt, for example, of ESA, and that gives them a gateway to other services. If you were to leave assets to a beneficiary outright, they will probably lose those benefits. And in some cases, leaving them in a trust to which they're entitled to the income will also affect those benefits. So looking at the other options, such as a disabled persons trust or a discretionary trust, provides some flexibility. And then long-term care. And again, this is for many people one of the biggest concerns about making sure that if you die before the person who might need care, then you might want to ensure that they have access to funds without them owning the assets outright. And really, a will is the only way to do that. But it's important that you do that as a couple before the need arises. This is talking about wills for each other. I should just mention statutory wills. So a statutory will is a will that is made for somebody who lacks the necessary capacity to put a will in place. Now, it is possible to ask the court then to make a will for somebody who lacks capacity. It is quite an expensive process and it is time consuming. It's the Court of Protection again that deals with these types of application, and you would normally only do it in circumstances where there was an overwhelming need for a will to be put in place for somebody. So it is an option. But ideally, again, as I said at the outset, if you put a will in place whilst you're still relatively young, in most cases, that will cover you through quite a long period of time. There's no guarantee that it will be the last will you have to do. And although we often suggest that you review your will every 3 to 5 years, we're not suggesting that you change your will that frequently. Most people don't need to. So you can provide for children, you can provide for grandchildren even if you don't yet have them. You can provide for children if you don't yet have them as well. It can be more difficult, but you can future-proof your will to quite a large extent. But if a diagnosis of dementia, for example, has been made, as with lasting powers of attorney, that's really a trigger event to start reviewing your will and checking whether it's fit for purpose, and making sure that you do have the appropriate arrangements in place so that it protects your assets, your joint assets, for each other, but also for your children or whoever it is that you want to provide for. When we're younger, we can have more complex affairs. We've got mortgages, we might have business assets. Some people have foreign assets, and those can still be covered in some cases in a UK will. But doing a will is also a sort of a trigger event for thinking about your other financial arrangements, perhaps your pension. It's important to make sure that you've written the benefit of your pension into trust, any life insurance that you have similarly, because from an inheritance tax point of view, it's a lot better to try and keep those assets outside of your estate. And if you have written the benefit of them into trust, then those will pass in accordance with the terms that you've set up, and not into your will. So it's really putting a will in place should be a holistic event to look at your overall circumstances. All situations are different. And I want to highlight that although I've run through very quickly, I appreciate a whole number of factors to think about. Not every one of these factors will apply to everybody, and they can be used in different ways depending upon what your own individual circumstances are. But I want to certainly get over that a trust is not there for the very wealthy. In fact, these days, trusts really don't have much of a role at all to play for wealthy people, but they do where you have vulnerable beneficiaries, and that really is where they come into play. Choosing your trustees is really important. Who's going to make decisions? Who's going to be best placed to manage the trust? And there are really two sides to that. The ability to be able to manage a financial fund, to take investment advice, and to make decisions about how the money is used. And then separately to know what the circumstances and needs of the beneficiary are, and what the trust might be used for, how it can be used, You need trustees, again, like attorneys, you need trustees who are going to get on. You may have exactly the same people as attorneys and trustees, because although the roles are different, there are a lot of similarities. Trustees are very likely going to need to complete tax returns, at least at some stage. So they need to have the wherewithal to be able to understand what their role is, what their obligations are, seeking the necessary advice where they need it. I think it's important to mention that you don't need to have a professional trustee or professional executors. Indeed, in many cases nowadays, it's going to cost too much to do that, frankly. And you're better placed to have a family member or good friends as trustees who know when they need to call upon professional support, rather than having a solicitor, for example, or an accountant involved the whole way through. If somebody's circumstances are very complicated, or if there isn't a family member, then again, there may be an advantage to having a professional as a trustee or having a professional as an attorney, but it absolutely is not required. You know, even with a trust, because you can use a professional to help you set up the trust, you can use a professional to assist with the practical arrangements, such as setting matters up with the revenue. But long term, you want somebody who knows the beneficiary well, who can make decisions on their behalf, knows what their circumstances are, to be involved in the day-to-day role. So in conclusion, before I get to any questions that you may have, I think it's really important, if a diagnosis of dementia has been made, at that point to look at checking that you've got your financial and welfare decisions in place. Put the lasting power of attorney in place as soon as you can. As capacity diminishes, it becomes more and more difficult for somebody to understand what a power of attorney is, and therefore to put it in place. So doing it sooner when they can see the benefits. And we should all do it. And I do recommend that when I'm working with somebody who perhaps has been diagnosed with dementia, I recommend that everybody puts the power of attorney in place at the same time. That can make it a lot easier to do. And it's the right thing to do, because none of us know when we might need to have the financial arrangements put in place for us. And then if you have a will, review that at the same time, and if necessary, make changes to it and future-proof it as much as you can. But as I've said, everybody's circumstances are different. You probably would need some assistance with the will if you're putting a trust in place, some professional support, but not necessarily for the lasting power of attorney. Lots of people manage to put lasting powers of attorney in place without a professional being involved. I think it's probably worth just mentioning that the test of capacity for a lasting power of attorney can often be seen as the test of capacity to fill out a form, because lots of people find that the forms get sent back because not everybody's signed in the right place or in the right order or put the right date in. It is important to work through it carefully, effectively from start to finish. The donor signs first, then the attorney signs, in that order, and provided you work through it in that way, you shouldn't get into too much bother, but it is certainly worth a final check over before you actually submit it, because the biggest problem with powers of attorney is actually the ability to fill the right information into the right box, not whether somebody's got the capacity or not. Okay, thank you very much. Any questions?
Hi, Jacqueline. Hi,
Thank
everybody. My name's Catherine. I'm the coordinator for the Young Dementia Network. I've just been watching the webinar here and looking at all the questions and answers. So thank you, Jacqueline, for a really interesting webinar. We've got some questions that have come through from the attendees. I'm going to read them out to you. So the first question is it correct that attorneys can provide a code given by OPG instead of a paper copy?
It is now, yes, very much so. So when you've registered the power of attorney, then the public guardian provides that information.
Okay, fantastic, thank you. The second question is, my LPA registered in Scotland for health and welfare. Is it valid in Wales?
Yes, we do have different legal systems. So the Scottish legal system is very different to the English and Welsh system. They are not automatically recognised, and they look very different. So Scottish power, they have continuing powers of attorney, do look very different. So ideally, if you have assets in England and Wales, you should have an English and Welsh lasting power of attorney. You will struggle to get a Scottish one recognised. And kind of vice versa, although I know a lot of insurance companies are based in Scotland, they will recognise an English lasting power of attorney, provided that the person is based in England.
Okay. The next question is, the house is in my name only, but our bank account is in joint names. Would it be advisable to have separate bank accounts?
There are a whole number of reasons to have separate bank accounts, and practical reasons for having joint bank accounts. One of the issues that often comes up with separate bank accounts is obviously, first of all, then if you don't have capacity, you really need to have some arrangement in place to be able to operate it. But this does become a bit of an issue if you're looking at long-term care and financial contributions to the cost of care, because if you're asking for the local authority to, because of your level of capital and income, you're applying to the local authority for assistance with funding. When it comes to a joint bank account, they will just split it in half. And that means that even if the person who's gone into care perhaps has a lower pension, the person who's not in care, their pension will be contributing to the balance on that joint bank account, and so indirectly they will be paying for care that they have absolutely no obligation to pay towards. So in those types of circumstances, it can be preferable to have separate bank accounts, because it ensures that if somebody's being financially assessed, they are only being financially assessed on their own assets and income, and not inadvertently by somebody else's. But that does mean, of course, that you'll need somebody who's got authority to be able to manage that bank account. But it is often preferable to do that, and it also makes completion of the form a lot easier when you're managing somebody's finances separately from your own. But I do appreciate, for a lot of married couples, we go through life running one joint account because that's how we pay the bills on the house and so on. But you kind of have to change your mindset as to what financially is going to be better for you, and sometimes in that case splitting it. The issue about the house, again, that can be a factor in terms of paying for care, although if you're a married couple and the person who owns the property goes into care, then certainly if you're over 65, the value of the property is totally disregarded. Younger than that, again, generally it will be, because it'll be your home, and it may be a home for younger children and vulnerable children. So that shouldn't be too much of an issue. But then, you know, the intestacy rules and so on that I talked about. So it probably is worth just thinking about what is best in that particular case.
Okay, thank you. Question now about online only banks. How do you register with them? That's the question. Okay, so you should still be able to register in exactly the same way as you do for another bank, but they have an online process for doing it. So it isn't any different. But often you have to you have to be able to scan over documents and so on, because if you're going to be acting as an attorney, I didn't mention this, but when you start acting as an attorney, you also have to identify yourself
So you have to go through the same money laundering rules that you would if you were opening a bank account, and provide the bank with proof of your identity, your passport or so on, and proof of your address. But it should work in exactly the same way.
Okay, great. Another question here is, can you give a child the right to live in your property on your death and not have to sell it to divide it with siblings?
Yes, in simple terms. I mean, that again, that you can do that in a will. So you can give a child the right to occupy it for their lifetime. That can cause some tensions with other children who might be concerned that they're not getting what they might perceive as their share. But it really comes to being open in those circumstances with your children about what you're doing, so that they're aware of the situation. That's not an unusual situation where perhaps that child who's living at home has provided care for a parent, and hasn't gone out perhaps and bought their own property. But it does open up the potential for not necessarily dispute, but perhaps a slight disagreement between the siblings as to when they might be getting what they might perceive to be their share. I should just say that you don't have to leave something to your children if you don't want to. I know it's very usual, but unless somebody is financially dependent upon you, then they may not have any entitlement. And adult children can find it quite difficult to successfully make a claim, because the court's view is that unless they had a financial tie, then the parent can do what they want.
Yeah. Okay, well, I think that's all of our questions. We had 5 come through. I don't know if anyone else has got anything, pop it into the chat there, but nothing else has come through. So thank you very much for answering those.
You're welcome. Thank you.
Somebody's just checking because they lost connection about the response to the Scottish LPA, and is it valid in Wales, and that there was a response to that. So I think we'll make sure that that person gets the response.
Yeah.
Is that okay?
Yes, sorry. Oh, and something else has just come through about advanced planning. That's just...
What's the question there?
It just says advanced planning. Do you have any, would you like to put more information there into the chat so we can answer that question? Nothing else has come through.
Was it thinking about advanced directive or advanced statement, that sort of thing?
For DNRs.
Okay, yeah.
That kind of thing,
so you can, an advanced statement or an advanced directive or advanced decision or living will, they're all sort of the same thing, is a direct decision from you when you have capacity to the doctors treating you at a time when you don't, to say that in particular circumstances you would not want this particular treatment. So DNR is the most often referred to, but it can be any number of treatments that you might not want to receive. It is important that you know at the time that you put that in place what you're doing, and strictly any such instruction should be in writing and signed. And that's what happens when you do an advanced decision, because you set out very clearly what treatments it is that you want to refuse and when that might arise. You can also now do this effectively within a health and welfare lasting power of attorney, because there is a section about life-sustaining treatment and giving your attorneys the right to make decisions on your behalf at a time when you lack capacity about refusing or consenting to life-sustaining treatment. The advantage of doing it through the lasting power of attorney is that you don't need to set out exactly what treatment it is and what the circumstances are. So it leaves it open, because often we don't know what it is, but within families we may have had a discussion that says, I don't want too much treatment. So it means that the attorneys can make that decision for you. The disadvantage is that you're leaving the attorneys to have to make the decision, whereas if you've put it into a living will or an advance decision, then the decision is already made for you. Most people who put a health and welfare power of attorney in place do give their attorneys this authority, because if you've discussed it within the family, then it means that you've had the discussion about what your wishes would be in particular circumstances, but you can do it either way, and you can have both. But if you have both, it's important to make sure that if you've already got a living will, at the moment a subsequent health and welfare lasting power of attorney would revoke that living will. So if you don't want to, you need to be very clear that it still remains valid.
Okay. And one more question's just come through, Jacqueline. If you get divorced, what continues and what needs setting up again?
Is this in a will?
I think.
Okay. Well, actually, it applies to a lasting power of attorney as well. So divorce removes an attorney. So between a married couple would remove an attorney unless you very clearly stated that it didn't. And similarly with a will, your spouse will be treated as though they've died before you. So if they were an executor, that would be no longer, and if they were a beneficiary, that would no longer take effect, and whatever the next provision is would apply. Usually somebody's advised to make a new will before they actually get divorced, because whilst they're still married, their will may provide for their spouse and they may not want to do that. But certainly when you get divorced, you ought to be making a new will. Equally, when you get married, you ought to make a new will, because again, when you get married, that will automatically revoke any existing will that you had. So you would be intestate. So in either circumstance, again, that's one of those trigger events to think about. Do I need to change what I've got?
Okay, thank you. That's all the questions. So thank you for answering those.
Gosh, thank you so much, Jacqueline. You've covered really important things for us all to consider, and you've done it in a really clear way. And thankfully, we've got a recording so that anyone can go back over any part of it, and we'll send that out in the link. But yes, thank you so much. It was. I always learn. You know, even if you, for example, I've got LPA and wills in place. Actually, you know, always learning, always needing to sort of think about refreshing, and you know, those trigger points that you mentioned as well. Always so useful. Thank you so much. And lots of comments coming in on the chat to that effect as well. So thank you very much for that. Great
Pleasure. Thank you.
Thank you, Jacqueline.
So as I said, we will send out the recording as ever, and any useful links. I think Jacqueline, you suggested one for the Office of Public Guardian, and if we think of any others, we will add them. And look out in the next few days for news on our next Tea Time webinar. It's on October the 20th, I believe. So, but look out for news on that. And other than that, thank you so much for joining us, and look forward to seeing you and meeting up with you again.
Thank you.
Bye-bye.
Thank you.